Lord Alton.
Thank you, Chair, and thank you very much for the responses you've been giving to the questions, especially around Article 8. But can I move you on to Article 14 and the potential infringement on questions of discrimination as a result of the use of surveillance or artificial intelligence?
Be happy to start with that.
Please do.
So part of my team in Oxford we focus on both discrimination and data protection aspects of algorithmic management. And probably amongst the challenges with AI, bias and discrimination are the most extensively documented. And to some extent, some issues with bias are actually inherent in the way that machine learning works, because ultimately it's about identifying patterns, and identifying patterns is also about identifying outliers. And so therefore what frequently happens is that it's inherent in some deployment of AI technology that there will be bias against people who are less than typical, which might, of course, often then overlap with protected characteristics. So one very extensively studied in the computer science literature illustration of this is facial recognition.
Right.
So Timnit Gebru and others have done extensive work looking at facial recognition systems that work particularly well with white male faces, and the further you move away from that, the worse the recognition gets. And we're not just talking a sort of gradual decline, we're talking about a serious uptick in terms of just how much worse systems are. Now, the way this plays out in the employment context, for example, is that various rideshare operators might say to drivers, before you start your shift, you have to look at your phone to identify yourself. Now, somebody who's not recognised will then be accused of fraud by the system for trying to illegitimately log onto someone else's account, and eventually might be terminated from their employment, not because they've actually committed any fraud, but simply because the technology discriminates.
So the technology itself is not perfect. It does mean that in some cases, especially where it's people of colour or different orientations or whatever characteristics, as you say, may be engaged, they could end up being discriminated against as a result of the use of this technology.
Absolutely, and particularly so in intersectional cases of discrimination, right, when the various protected characteristics start adding up. Now, the legal problem, and this is work I've published with Aisling Kelly-Lyth and Ruben Binns, and I think is on record with the clerk of the committee. Additionally, the analysis is then to say this is indirect discrimination, right? This assumption that the algorithm is a neutral practice or criterion, and that therefore then, crucially, the employer can deduce a justification. And of course, in the context of facial recognition for a driver, you could say public safety is an important justification for this. You don't want some random person in the back of your rideshare. However, that means that you de facto then legitimize and legalize significant amount of discrimination. So one thing we've been arguing in our work is that actually direct discrimination should be applied to some cases, such as facial recognition discrimination, because ultimately that is discrimination on grounds of or because of the protected characteristic. And so in our work, we've shown and suggested that actually you should bring these claims as direct discrimination. So employers could not, particularly with things like facial recognition systems that are known to be discriminatory, employers should never be able to justify their deployment.
I'm going to add to that.
Would you like to?
Yes, yeah. Happy to. Perhaps something worth flagging, and very much agree with what Jeremias has said on that. Our own work and our analysis as part of the Equality Task Force, which was chaired by Helen Mantfield QC, points to that very strongly. Is that there needs to be, it's very difficult to access information. So there's a real transparency and explainability issue, which starts off with understanding basics about the purpose, as we've already highlighted, and the model and the factors that are being considered, and how the trade-offs are being made, with the impacts, which our work suggests are sort of a full range of impacts right across the conditions and quality in terms of work. So you need a kind of a new AI literacy and knowledge and shared language to be able to sort of to kick off, which is one of the ways in which human rights can really help. It's also right that decisions that are really key decisions, human decisions which shape the outcomes, are often diffuse, and they span multiple organisations. So, for example, it's very, in thinking about a recruitment tool or people analytics, it may well combine in-house tools, procured tools, and data purchased from data brokers. The language of statistics too often obscures the human roles and gives a kind of air of certainty or neutrality, which needs to be unpicked and is difficult to unpick. And of course we have huge sort of information asymmetries, so tools that simultaneously are requiring more granular data, often as part of work, and sharing less about what actually happens to it.
Thank you. And Sian, in just answering that, I mean, with the committee's previous inquiry, which was into the illegal migration bill, we had an issue around age verification. In fact, Parliament will be debating it further. And we were told that really this was just never certain. It couldn't identify with any degree of certainty the age of a young person, a child, as to where they actually were on quite a wide spectrum. And we've seen the growth of surveillance equipment, and there are 1 million Hikvision cameras around the country, some of them being used in places of work, but owned by a company that's directly affiliated to the Chinese Communist Party. I mean, what alarm bells should be ringing in our heads about the amount of how many of the scale of these operations that are underway, the people who own them, and the potential, therefore, for their abuse?
I think it is really important to identify when we're talking about AI and this large-scale surveillance, which obviously it is important to understand who operates CCTV, and AI in the workplace, which is obviously often a much smaller scale, and we have these clear principles where if you are going to deploy it in the workplace, you need to be carrying out this assessment and identifying the purpose for which you have used or want to introduce it. So AI, CCTV by itself to protect premises or to identify, who is attending at your offices, and for the security of, for example, the people who work in the building, you can see that that's much clearer to justify than compared to AI, where it's unknown what the purpose is. When surveillance, where it's unknown what the purpose is. In the workplace, again, I think it's really important to be clear about what it is you are using for, not least because, as Jeremias pointed out, in the event of a claim, if it is an indirect discrimination claim, then we look at objective justification, which is a very similar test of looking at whether you have acted in a proportionate way to achieve the legitimate aim. But just picking up on what Jeremias and Anna said, I think there are a number of other ways in which Article 14 rights are engaged. So if we think about an algorithm that's trying to predict who the best candidate is for a CEO role, for example, when in 2020 there were 5 female CEOs in the FTSE 100 and there were 6 called Peter. So we certainly would want to be very careful about the data over which that AI has been trained. But if you are buying in technology from a organisation, you may not know what data it has been trained over. And so I agree entirely with Anna, it is incredibly important to have transparency and explainability. And not least because the way in which the Equality Act works in a claim of direct discrimination is we have the treatment and we have a difference in protected characteristic, and then we need something more, but it doesn't have to be very much more. So in a recruitment context, you could have this person is a woman, this person is a man, and they both appear on the face of their CVs to be equally qualified. And that raises a presumption of discrimination, and the burden then shifts to the potential employer to demonstrate that the reason for the treatment had nothing whatsoever to do with the protected characteristic. And there is European case law, where in a different context, not in the context of technology, but which does say where there is a lack of transparency, that might itself be enough to shift the burden of proof. And if the employer or the potential employer has bought in this technology, does not know what it is trained over, and it is what we sometimes call a black box, cannot explain how the technology has come to a conclusion, then the potential employer is the one who is on the hook under the Equality Act for the decision, even though the potential employer may not be the one who has chosen to discriminate. So when we are thinking about what we need in order to explain, from my perspective, it's really important that there is an obligation on the developers of these technologies to provide information about what it has been trained over and how the decisions have been reached. And that may involve being transparent about the jurisdiction in which something has been calibrated. Obviously, can sometimes be a sales pitch, and organisations can say, oh no, we've taken the necessary steps to ensure that there's no discrimination. But if you do that in the US, for example, that may not be sufficient to defend a claim in the United Kingdom because of the difference in the jurisdictions. But in the United Kingdom, it is the decision maker, the employer, who is the one who is liable under a claim for unlawful discrimination. There are, I should add, aiding and abetting provisions, but that's probably too far for the purpose of this inquiry.
Very interesting. Can I bring Catherine?
Very clear, and thank you very much indeed.